Hey everyone, in our Violation of Probation podcast, we had a lot of value to provide. So we have a continuation. Here's episode number 2, and you're not going to want to miss the end. Welcome to this episode of Badges to Briefcases of the Gans Law Podcast. I'm your host, attorney Brandon Gans. But man, they don't make it easy.
No,
you don't want to be in that situation.
They don't make it easy. And I think the judges are aware that the standard is lower, right? That the state has to meet. And at least in my experience, I've been fortunate enough that they do kind of like, even though the state will meet the burden and the state got it, okay, cool. But when we get to the sentencing and I make my argument to the judge and I say, look at these facts, like, we're asking for you to be reasonable. I think for the most part, they put everything into consideration and, it tends to still be okay. But it goes back to what you're saying. You got to make those arguments once you're there.
Yeah.
Once the state has met that burden, now you got to kind of present further argument in closing to the judge on why they shouldn't be harsh on their sentencing and hope that they put it on a balancing scale,
Right. And that's why it's so important to know your judge.
You got to know if they're going to, I call it splitting the baby. Are you going to split the baby where you're like, okay, state, like you met the smaller burden. Cool. On the record, you met it. But I can also see some points that defense had here. I have seen judges before blatantly say, state, you've met your burden. Had this been not a VOP hearing, had this been a real trial, you would have never been able to prove this new law offense. And that is why I'm going to put that into consideration and my sentence is going to be and then it tends to be a lighter sentence.
And on that point, the sentence doesn't have to be jail.
No, it doesn't.
If you violate probation, even if the judge finds it, but he finds it's de minimis, meaning very minimal, he can say, you know what, I'm going to reinstate the defendant back on probation, maybe tack on some modified additional conditions, extra community service hours or what have you, and the person can finish up. He could also revoke and terminate, sentence to a new term. Yeah. And then the other danger with the VOP is that you're actually exposed to the entire length that you would have been originally.
Exactly. Scary.
Yeah. So to say, for example, you went on probation on a third-degree felony and you got 24 months probation. Well, if you violate, your maximum exposure in jail isn't 24 months. No. It's the 60 months or 5 years.
Yeah, people don't see that. Most of the time, they're not aware of that. And that's something you have to counsel them when they're finding themselves in that situation. You have to tell them, like, you're facing the original amount that you would have, not the rest of the amount of what you had left. No, like the original amount that the law says this crime can be punished by.
Right, which is why when we put people on probation, let's say they have 3 third-degree felonies, 5 years each, you're looking at 15 years. If I can get 2 dismissed, put them on probation on 1, or just on 2 of them do adjudicate court costs or withhold court costs, probation on 1. What that means is if they violate, their maximum exposure is 5 years, not 15 years.
Exactly.
Because I have to presume that they might violate.
Exactly. No, I mean, you always have to, with anything, you have to always be 2 steps ahead and think, how could this affect the client long term?
Exactly. Even if the client's not thinking about it, we need to be thinking about it. Because I might see you 12 months down the road on a VOP that maybe wasn't even your fault, but now you're looking at 15 years when you could have been looking at 5.
It's important to have those conversations with clients. I know I have them. When they I told you, when they take these probation sentences, I'm like, probation's a scam, and I'm going to tell you, be on the lookout for this, and I warn them, and I tell them, like, it will be harsh if you end up violating, doing X, Y, Z, you're going to find yourself in this predicament. There's some times where judges will, even when they're letting them take the probation offer, will tell them, if you violate and you are back in my courtroom, I promise you, the minimum that I will allow will be jail. So make sure you do a good job, And it's like you have to make these clients aware of that because probation's a scam and the stakes are high.
I think that's the theme of the day.
It is.
Yeah, and I've had clients too that, like, Brandon, I've been on probation, they vouch me, I can't do it, I'm gonna test dirty, I know I can't do it. Can I just do a straight jail sentence?
That's respectable.
So instead of doing 36 months probation, maybe I get them 30 days, even 60 days in the county, and they're happy with that.
Absolutely.
Because they know they could do 24 months probation, and that 25th month, they violate. So now they've been under supervision for 2 years, complying with all these conditions. They do the violation probation, they get 180 days. So they'd rather just do the 30 days up front
100%.
and skip all that stuff. And then when they're out, they're free. They don't have to check in with anyone. They don't have to do anything. There's no cost. So
I definitely have seen that too. And every time I've been in a situation where someone says to me, no, like I'd rather get a jail offer, please. I'm like, I respect that because, you're aware of what you can do and what you cannot do. And you're trying to prevent yourself from being in a worse situation down the road.
Yeah, because like we talked about, not only you're giving up your rights at a VOP hearing, you're giving up your rights before that because with violation of probation, we talked about you're giving up your Fifth Amendment right, the right to not self-incriminate, but you're also giving up your Fourth Amendment right because sometimes condition of probation is what?
There you go.
Warrantless searches.
Absolutely.
So
absolutely.
What does that mean?
It sucks. It basically means they're going to be able to, look through your belongings, go into your house, search without a warrant, and that's the protection that we have in this country of our Fourth Amendment right. But you're put on probation, and in essence, you're being stripped of that too. And I mean, I've said it before, the Fifth Amendment right is one of my favorites, but my God, being stripped of your Fourth Amendment right, I think people don't realize how much of a big deal.
Yeah, because probation on a whim can come into your person, your car, or your home.
It's crazy.
And they'll come into your house and they'll find drugs or a gun, and that was your roommate's. Yeah. But guess what? It was in your house, even though you didn't know about it and it wasn't yours.
Absolutely.
And they didn't need a warrant. Yeah. They didn't need any probable cause.
Yeah.
So I think people do get set up for failure in that sense.
Oh, yeah, that's a big one. And that also brings to mind too, another danger of probation is you have to be mindful of who you're hanging around too, because it could be as simple as, you have, you're with a group of friends, you're not necessarily doing nothing wrong, but maybe they get in a fight, things get out of hand, now you're there, next thing you know, you're getting wrapped up in this big fight that you weren't even part of, and they're realizing you're on probation, boom, violating you, and they're assuming that you were part of this brawl or whatever. Like, you have to be very cognizant of everything, from the people you're hanging out with, the places that you're at. I mean, it's just such a burden.
And it's not just your enemies that get you in trouble, it's your friends that get you in trouble. Not just in person, but online. Like social media, could that get you in trouble too?
Absolutely.
So if you post
I've
something,
seen it. Yeah, I've seen it.
Do you think probation officers take a look at your social media?
Absolutely. I think that they're monitoring everything, I mean, that would be the advice I would give. Like, there is nothing, I want you to feel like you are being watched at all times from every angle. Yeah,
you go take a trip with your friends, you want to post about it, look at the great food, the sights. Probation's like, oh, you didn't get permission.
And they're going to use it. Yeah. They're going to use it. They are going to take I've seen it. They are going to take a screenshot. They are going to attach it to the affidavit of violation of probation as evidence, and then that's for a defense attorney to have to fight. But they do it. They do it. They don't care.
Yeah.
They don't care.
Have you ever seen someone on probation where like just a little mistake completely change everything for them?
On probation, I wouldn't say small. I've seen more of bigger mistakes that I'm like, which I think is worse. I don't know, in my opinion, because it's like, come on, this is a big mistake. Like, you should have known.
I know. And sometimes something small they don't even think about. It's like, now you did something small, but now you're getting arrested. Because you're in jail on no bond, you lose your job. You can't make your car or house payments. I mean, there's a lot of
there's a lot of stuff, because there are some cases where, like you said, most of the time that violation probation warrant is gonna carry a zero bond, and there are judges that you'll fight for a bond and they won't give it to them, and they will sit there while the attorney resolves the violation probation case for a bit.
It can be a while.
It can be a while.
It can be weeks or even months.
Oh, it can.
And then you get to the VOP hearing, and the state's like, oh, a probation officer's on vacation or in training today. Okay, we'll set it off for another month. And the person's sitting in jail the whole time.
And then sometimes, we all know it depends on the judge's docket too. Like, they're busy and they're constantly, handling a lot of things. And sometimes the next status date is going to be a bit out. We can be at a status date, let's say, second week of March, and next thing you know, the next status is at the end of April, and you're like, that's a whole month and a half, 6 more weeks, and people don't realize, you're gonna sit there for 6 more weeks until now we can get to the judge again and resolve this, unless something happens, obviously, behind the scenes between defense and the prosecutor where an agreement is made, and then now we can handle it ahead of time. But it can take time, and some judges will just not give you a bond.
Yeah, and there's lots of violations you could have because you have general conditions of probation, right? You have specific conditions. So general is presumed it's your normal stuff. The judge doesn't have to, orally pronounce it, but he does have to orally pronounce any special conditions, right? So special conditions kind of where, the judge set it out and there has to be a certain deadline, right? You don't have the whole term of probation sometimes, right? If the judge wants you to take a class,
they can put a deadline.
A deadline, they'll give you, okay, you have to do this within so many months, do that within so many months. And then you could be violated and say, Judge, I still have 5 months left on probation. Doesn't matter.
And they don't care.
Because you didn't meet the deadline of that specific special condition.
Yeah. And they'll even put a deadline as to by what time you have to enroll. It's not even just completing. They'll say within 30 days of starting probation, I want you enrolled in this class. And within, 45 days of the enrollment, I want it completed. They literally will be very specific.
I've seen it too where like you have to enroll within 20 days, whatever. Well, it's a very specific class that's not always offered all the time. So they will make a good faith effort to enroll in the class. But the class says, I'm sorry, we don't have registration for the next 4 weeks. You got to come back. Oh, you go to register.
Sucks.
Oh, you didn't bring your police report. You got to go back home, make another appointment. And then you could violate it on just something silly like that.
Simple. That's very true.
Yeah. And then sometimes there's special conditions like, I mean, if you committed like an offense that involves a computer, sometimes a condition will be like, you can't use the internet. Imagine.
Oh yeah. In today's
world, not being able to use the internet. You can't do anything.
And like there's
you can't use email,
internet
you can't
for
work.
Everything. Exactly. That's what I was gonna say. Think about it. Email, these phones, obviously have internet on. It's just horrible.
Yeah,
I hate it. It's a scam. It's a scam.
All right. So because it's a scam, what if you're like, all right, I got to put an end to this. I know the judge sentenced me to, 4 years probation, but I can't do it anymore. Is there any way that they could cut it short?
Yeah, of course. So, obviously there's statutes in the state of Florida that govern what can qualify for early termination of probation. In a nutshell, if you've been good, haven't committed any violations while you've been on probation, and you've satisfied all of those conditions, completed community service, are up to date with your supervision payments, the fines they had you issued, the classes are completed and turned in. Basically, everything is checked off and done. Once you get to the halfway mark of whatever your sentence was, so if it was 4 years, at 2 years you qualify. It's not just any time. It's at the halfway mark. Then you can, have an attorney file a motion to early terminate. But the caveat is you also have to make sure that part of the stipulation of your probation officer offer was not no early termination.
Yes.
Because sometimes they put it, so you have to really make sure that wasn't part of your deal. Like, the deals I take, I'm going to make sure that it doesn't say that,
Absolutely.
Because that sucks.
And I think a lot of people don't realize that. If it was a special condition that you not be allowed to early terminate, then you can't apply for early termination.
Exactly. That's it.
Which is why I personally, when I'm taking a plea deal, I'm already thinking about that.
Of course.
And I know a lot of attorneys will try and get the state to stipulate to the option for early termination. I don't bother.
Yeah.
Because then it puts it in their head and they say, no, they can't. Well, now you've just screwed your client essentially. So I'm just silent as to it, because silence means there's been no objection. So I won't even bring it up.
Yeah, that's a very good point. But that's a good point. Yeah, don't take an offer that says no early termination, because I mean, if you do your job, your responsibilities, your thing right while you're on probation, there is a statute that says you can apply for that early termination if you satisfy it.
Is there a time that you recommend people put in for that?
I mean, right when they're getting to that halfway mark and they know that they have satisfied fully all of those conditions. I mean, for an attorney to prepare that motion is fairly quick. Where it can take a little bit of time is the response of the prosecutor. We try, to get ahead of time their position on it, because sometimes it could be signed in chambers without having to get a hearing in front of the judge, which is the easiest way. Prosecutors are busy. They're busy as well at the end of the day. So that can slow it down a little bit, especially if you have a client that's saying, I want this done as fast as possible. That could make a drag. So I would say right when you're getting to the halfway mark, make sure your T's are crossed, your I's are dotted, all of those conditions are satisfied. Call an attorney, have them file that motion. Right at that halfway mark, get the ball rolling. That's when you'll qualify.
I agree. Yeah, getting an attorney involved early for the early termination process is
Yep.
really critical because there are a lot of steps to go through.
Yeah.
And we want to work quickly because we know we want to get off. Each month that you're on probation is more supervision costs and everything.
Absolutely.
What about hiring an attorney for a violation of probation? When would be a good time for that?
ASAP. ASAP. That is one, man. I always say ASAP, hire an attorney no matter what, but I would say this is one because it's just like we've said, like you're probably going to sit there with a no bond. Most judges, even if we do a bond hearing, most of the time will be tough on wanting to give a bond. Not saying it doesn't happen, but it's tough, you know? And so you're going to need an attorney from the inception of this, especially if, like we've said, it's maybe a technical violation that didn't even occur. And we can clear this up very fast and get you out.
Yeah, and on that point, I'd say even before the violation, because I know sometimes we've seen it where someone's like, I think I'm going to be violated.
Absolutely.
And usually you know, right?
Yeah.
And we can reach out, like if there really was no violation, or we can explain it away, get in touch with the probation officer and see if we can smooth things out before they file that affidavit. Once they file affidavit, it goes to the judge for the warrant. The time under probation is told, meaning your time stops. It doesn't keep going, so you're not getting credit for all that time. And there's been times where I can get ahead of the curve. And even if there was a very minor violation, sometimes I can talk the probation officer into can we just give him a court date? I don't think we need to really get a warrant involved, and just see if we can especially if it's like a county court misdemeanor probation. Can we just give him a court date?
And sometimes the prosecutor too will be on board and they'll see, it wasn't really that bad. They're almost at the end of their probation sentence. Man, this sucks. They've done good. And sometimes in the background, they'll be willing to, come to an agreement with us, and it doesn't have to go left. That's why it's so important to just hire an attorney ASAP.
Yeah, agreed.
ASAP. Yeah.
All right, we're gonna do a few rapid fire questions.
Oh, okay.
What do you think is the biggest probation myth?
Probation myth. What's the big probation myth? I think that people, what I get questions about a lot is that people assume that just because you go on probation, you're always gonna be drug tested. And that I've seen plenty of cases that it doesn't happen. They assume that is always a hard and fast rule that is attached to probation, and that's not the case. So that's a misconception.
That's very true.
Yeah.
And despite that, I think we still tell the clients, be prepared.
Yeah, no, I tell them, but you're at their mercy.
Right.
Anything can happen,
right.
even though it's not stipulated. But people automatically assume that it's automatically gonna happen, and that's just not how it works.
That's a really good answer.
Yeah.
As a myth.
Yeah.
I was thinking for a myth that people think probation is just a slap on the wrist.
No.
And it's
it's not.
Yeah. What's one thing that people should never do on probation?
Oh, one thing that just don't commit a new crime.
Yeah.
How about that? Behave.
I'll agree with that one.
Yeah.
What's the one thing that probation officers hate seeing?
Oh, lack of communication is what they expressed to me. Yeah.
That's exactly what I was going to say.
Yeah.
We're on the same wavelength.
Yeah.
What's the most surprising probation rule?
The one we talked about, that they, are essentially losing their Fourth Amendment right, and they can just, do these searches without a warrant. I mean, yeah.
Again, that's exactly what I was going to say.
Yeah,
We're in sync today. And finally, can one mistake really send someone to jail?
Absolutely. Absolutely.
Just one violation. Doesn't have to be a dozen violations. One violation.
One, like I said, as small as just not paying your cost of supervision that month. That $50 payment is gonna get you hung up. I hate it. I'm so passionate about it. I hate it. Yeah.
Sounds like you've been through it.
Sucks.
So what's what would you say is the biggest piece of advice you could give someone that's currently on probation or about to go on probation?
I still stand strong on the fact that communication is everything with these probation officers, because I've seen it as I've navigated probation sentences with clients, how a probation officer can make it work and be understanding. And like you said, sometimes even overlook some things and give them a second chance, and just give them a little pep talk and say, just don't do this again. I think communication can save you from so much. And it's just, don't be scared. Like, just talk to them, tell them. And then if they say no, now you know where you're at, and then from there, hopefully you make a good decision, on the violating. But I just think communication is everything, you know?
Yeah, I agree with that. And I think we've covered a lot of ground in today's
Yeah,
episode.
absolutely.
I think the important takeaway is that people should be aware of the pitfalls and the traps that could be laid on probation.
Slippery slope.
Having said that, for some people, probation is a gift, and probation can be very beneficial.
Yeah.
But I think we'd be doing a disservice to people if we didn't tell them it's not a cakewalk. There are many
Slippery
traps
slope.
that could be laid for you. You want to tread carefully on this. Having said that, it is important to know for some people it is a right fit. For some people it's a great alternative to going to jail, but you just got to be careful with it.
Absolutely. I agree. It's a slippery slope,
Yeah.
and it's better to, be aware of the in and outs and what can happen, especially how these rules work on probation, so that you can at least successfully make it to the halfway point where you can terminate if all conditions are satisfied and just get yourself out of it.
Exactly, because you're in jeopardy until you finish and you
That's
get
it.
that official order of
That's
completion. You're in jeopardy. So you're really, it could be a gift, but you
Absolutely.
got to be careful with
I've
it.
literally seen people, get the early termination granted by a judge and want to cry because they finally feel like they've gotten their life back, their
They're free.
rights back. They are like fully whole again, right?
100%.
I guess that's the best way to say it. You're on probation and you're not fully whole because you are stripped to a certain extent of all your rights, that you think you have, like the Fourth Amendment right, the Fifth Amendment right if we end up in a hearing. And it's like you're not fully whole, in my opinion, underneath the Constitution because you're missing some of these rights. So, yeah.
I think that's a beautiful way to end it.
Yeah.
I couldn't say it better myself. So again, it's been a great topic today.
Absolutely.
And I've been your host, Attorney Brandon Gans. With me, Attorney Danielle Padilla. I love having you on the show.
Thank you.
And
Love it.
if there's anything you guys would like to see, go ahead and drop us a
us
message.
know.
Follow us on all the socials, Gans_law, and we'll see you on the next one.
Bye.